Thank you to all of you for joining us today for our Condominium Association Board Certification course. I've probably given this course many times. I know I've given this course many times, but as Jeff mentioned, even if you've taken this course before, we're always trying to update it with new information. Obviously, all of you are probably aware of the new safety and reserve laws that were enacted last year. So we have now incorporated those requirements into the course. And I always, try to incorporate new talking points to keep it interesting and more conversational, and try to keep everybody awake out there in Zoom land. I can't see any of you, but once again, I appreciate you attending. I am in the Palm Beach Gardens office of Kay Bender Rembam. I'm actually a native of Palm Beach County, and I love Palm Beach County. I have been doing condo HOA law for quite a long time, and I would like to say that I have recently been appointed as the co-chair of the Florida Bar's Condominium and Plan Development Committee of the Real Property and Probate section. So that is another role that I serve in to try to help promote all of our condo HOA laws and try to obviously advocate for all of you out there watching and try to do the best we can in terms of legislation and other issues affecting community associations. We do have a lot of slides today in this presentation, and I will try to talk as quickly as possible. Sometimes I'll go into pretty great detail on some of the slides. Sometimes I might breeze past some of the slides. You can try to post questions in the Q&A in the chat, and if they're pertinent and I see them in time, I will try to respond to them as we go. But sometimes, as you know from attending these presentations, we just cannot get to the questions because we have a good amount of material to cover. You will get, and I think Jeff's already sent around a copy of the PowerPoint. So it is very detailed, and I would like to point out it's a good resource. I know sometimes throughout the presentation, I'll say star this page, or I guess you can take note of it since you don't have it in hand, and you can go back and re-review the details of that slide and use it as a little guidebook in your service as a board member or manager.
Yeah, we just placed the link for the slides into the chat, and it'll be available if you just want to follow along on the screen, folks, because Allison will be sharing her screen. You'll be able to see the slides. You can download them in the evaluation afterwards, but the link is now also in the chat. And Allison, pardon the interruption. I just want to mention one last thing. Please stick with the Q&A for your questions, and we'll get to those if we have time. Let's put only techie questions in the chat, like if you're having trouble hearing or following along and it has to do with technical issues, I'll monitor the chat for that. But all legal questions with regards to today's presentation, please stick with the Q&A and the Q&A only for that. Back to you.
Okay. One more thing before we get going, the Q&A. In order for me to actually respond, it needs to be short. I cannot have a lot of facts about your particular circumstance going on at your association, so please keep it general. That will promote a response by me. Once you start getting into very detailed facts or writing a lengthy question, it makes it too difficult to respond to. So with that, I will try to do my share screen now. That's not my favorite thing to do, but I think I'm competent at this point to share screen and go from the beginning. Which one are we seeing, Jeff?
We see the big screen with the notes on the left, the little thumbnails on the left.
Okay, let me just adjust that. I guess my competency at share screen isn't what I thought it was. I'm a much better lawyer than tech person. Okay, I'm going to put that out there right now.
That looks good.
All right, good. All right, we're good to go. Okay, here we go. So as Jeff mentioned, partly, why are we here today? We are here today because you are required by law to either take an educational course or submit a certificate of acknowledgement within 90 days after being appointed or elected to your board. This course obviously satisfies that requirement, and as Jeff already mentioned, you do need to take this course if you've come off your board for any period of time. If you've already been serving for years and years without interruption, it is not a requirement, but as mentioned, it is advisable to keep up to date on law because it constantly changes. If you've been serving on your board for a long time, you've seen these changes. And I will say that these changes enacted in the 2020 special session, SB4D, have really, serious changes and have really been the most significant changes I've seen during my years as an attorney representing condominium associations. So this probably is a different course than you've ever taken before, just due to those requirements. We will get into those shortly after, we get into the meat of the presentation. They are not at the back for those of you who are interested in those new requirements. The acknowledgement form, should maybe some of your board members not have the opportunity to take one of these courses. I understand people have to work and they're not available at 1:30 in the afternoon, and their schedules just won't permit it. Obviously, it's recommended to listen to an educational course, but you can also submit a certificate to the association acknowledging that you have read all of the association's governing documents, will uphold the documents, and will faithfully discharge your duties as an association board member. If you do not, I told you my tech criteria is lacking. If you do not either attend a course or sign the certificate within the specified time period, you are temporarily suspended from the board. That means that once you complete the requirement, you are then able to automatically get back on, but for the period of time that you have failed to complete it, you are off. And I will tell you that we do have unit owners searching official records to inquire about board member certification, and we do have unit owners quite often calling board members out for not complying with these requirements. A lot of the times the unit owners think that the board members are permanently off the board and not temporarily, but it is somewhat possibly of an embarrassment. So if you have fellow board members who have not completed this and you know that they need to, I would urge them to get with it. So very briefly, we're gonna go through some kind of legalese type stuff here, but stay with me because this is only for a couple slides, but I feel it's important to kind of preface the presentation with this information. As you probably know, condominiums come in different shapes and sizes. We all think of a condominium sort of as a tower, as you'll see there in the larger picture, and actually probably all of these photos. But down there at the bottom, we have a, just open land, and you could have a condominium, villas, attached looking townhome style condos, even single family type units can be a condo. We have land condos, that just one piece of land. Sometimes there'll be an RV style setup where the piece of land will be considered a condominium unit. So just don't judge a book by its cover here. Sometimes think that something is a single family home, not a condo, or a townhome HOA, Homeowners Association Act. It's not that easy. But all condominiums are subject to a declaration of condominium, and buying a condominium is sort of like buying a cube of air split up into boundaries, upper, lower, and parametrical boundaries describing the bounds of the units, what is included in the units, and then what is included in the common or limited common elements. Obviously, most of you already know that Florida condominiums are subject to 718, the Florida Condominium Act, and your governing documents. The governing documents of a condominium association are the Declaration of Condominium, Articles of Incorporation, and bylaws. And we have, Jeff Rembaum has a saying, a little dab will do ya, in terms of what document prevails over the other. So here, this is probably one of those pages that you want to become familiar with. That the declaration, I always say, is like the constitution of the condominium association. All of your most important provisions are usually set forth in the declaration. Those provisions are going to be more enforceable than other provisions. The articles are what incorporate you as usually a not-for-profit corporation. So in addition to being a condominium association, you are also you are running a corporation. You have a board of directors, and your corporation was formed pursuant to its articles of incorporation. That's sort of the formation document. And then you have your bylaws. Your bylaws tell you all about the procedure, how you organize meetings, what type of committees you may have as standing committees, what, how you deal with vacancies on the board, terms of directors, number of directors. But regarding hierarchy here, it's the declaration has the highest of authority document, then your articles of incorporation, and then your bylaws. And you probably say, I say this all the time, well, Allison, what about the rules and regulations? Well, they're not, sometimes they're not that important because they're not even on this page. The rules and regulations are the lowest priority document. The rules and regulations are usually adopted and amended by the board without a unit owner vote. They're usually not recorded in the public record. And you cannot include things in the rules and regulations that are going to be inconsistent with or conflict with the terms of your declaration, articles, or bylaws. So the rules are helpful for sort of everyday items, no hanging towels over your balcony, hours of the pool, hours of the billiard room, different little, I'd say, everyday items. But you have to be very careful in not attempting to use your rules to circumvent what's in the declaration. If you have a provision of the declaration right there in black and white, you really can't make a rule to do a runaround against what's in your declaration. And I probably talk about that more throughout this presentation today. You may have heard of this concept of Kaufman language. Well, Kaufman was a famous case, an appeals case in Florida concerning amendments to the Condominium Act, and do they apply or do they not apply? Well, that's a whole legal analysis that is very detailed, and I'm not going to talk about that today because I don't think you're here for that. But I will say that if you have this sort of magic language in your governing documents, your declaration is subject to the Florida Condominium Act as amended from time to time, then every type of amendment to the Condominium Act will apply to you. And that has its pros and cons. And a lot of times we'll see procedural laws apply across the board without respect to this whole Kaufman concept. But if you have some kind of substantive amendment to the Condominium Act that's adopted, let's say this year, 2023, we sometimes have to go through a legal analysis to see whether that amendment to the statute actually applies to your association or whether it does not. If you have this as amended from time to time at the beginning of your declaration, that this declaration is subject to the act as amended from time to time, all of the amendments will apply. And I'm not saying that that's the right way to go, because in a lot of ways, it's a risk tolerance type situation. You're then agreeing that all these laws in the future that you have no control over automatically apply. Sometimes that's a good thing, and sometimes that's a bad thing. You might not want to be subject to something in the future. As an example, I'll give you is suspension of voting rights. Suspension of voting rights is in the statute. If you're more than a certain number of days delinquent, you can have your voting rights suspended by the board. But we just had a new case come down a couple of years ago that said, no, that only applies to condominiums enacted or formed after that statute went into effect, or those declarations that contain this magic language. So that's where, it might be a good thing to have the language, but sometimes there's other issues that are different, and you probably don't want to have that. So for instance, if you want to have the ability to charge the highest late fee or interest rate that the statute might incorporate, in a couple of years, you would do sort of I would say a spot amendment, where you would add this language throughout your declaration, but only as to certain things where you want it to apply. Okay, I told you I'd try to move on from this legalese stuff, so I'm going to skip a couple of these slides. But I felt that was important to share as sort of overall principles. And just frankly, those can be pretty confusing. If you have any concern whether a specific statute the Florida Condominium Act applies to you or whether it doesn't, you do need to consult with your individual lawyer to determine that. So going into membership meetings, we all know that you have to have an annual meeting. Just because everybody's happy with your board and nobody complains and typically the same people serve over and over again does not give you the excuse not to have a meeting. We do need to call a meeting each year, and it needs to be called pursuant to the terms of your bylaws. The election usually is going to occur at your annual meeting unless it's the turnover election where you were under developer control and now you're not, or you have some sort of special runoff election, but the regular election must occur on the date of the annual meeting. Special membership meetings might be called from time to time when you're maybe proposing an amendment to your governing documents that needs unit owner approval. You're going to try to waive or reduce some sort of reserve contribution, which we will discuss in more detail going forward, which has definitely been impacted by the SB 4D new requirements of last year. I'm sure you've read all about this in many different news sources and probably through our firm's newsletters. And you are required to hold a special membership meeting when at least 10% of the unit owners or otherwise provided in your documents make a petition for you to call a meeting. So what about notice of meetings? Well, the statute always provided for a long time, and I'm sure all of you with older bylaws have documents that say you have to mail or hand deliver the notice of the meeting. But thankfully, the statute was amended quite a while ago, I mean, several years, to say, notwithstanding what's in your bylaws about mail or hand delivery, you can email notice with the consent of the unit owner. So a lot of times you will have a management company or somebody who's really dedicated on your board go forward with a project. Maybe you've already done this to try to get everybody on board with notice by email. Some communities like this, some communities don't, but I feel that this is obviously growing in popularity. So you don't have to mail out a bunch of notices, which, you know, I just heard that stamps have now, the mail costs have now increased again. So this is something that if you're not doing it, you should definitely think about doing it. Also, you might want to consider doing this or trying to get the consent of owners to email notices when they come into the community. So if you already did that mass request years ago, you got to keep up on it. So hopefully you know when new owners are moving in, or you have some kind of screening, approval, interview, orientation process, depending what's set forth in your documents. You can have as part of that package the consent form for owners to sign to say, okay, we're okay with getting notice via email, and you don't have to mail it out. It definitely has been helpful because mail is so slow these days. So when you only have a 14-day notice requirement, somebody might not get it until like day 7. If you email it, then people have more time to mobilize to be able to attend meetings. And a lot of time you're trying to get them to vote on something that's important, so you want to get their vote. For quorum, in order to conduct a membership meeting, you actually open up the meeting, you have to have what's known as a quorum of the membership. And that is a number that's provided in your bylaws, but typically speaking, your bylaws are likely to provide that a majority of all owners constitutes a quorum, giving you the ability to start conducting business. Sometimes there's a lower number in the bylaws, you know, especially if you have a lot of investment units and people who are not there, or a mixed use condominium with commercial and residential, we might see something like 40% or 33.33% or 30%. So that's a document specific issue. And I'll say throughout this entire presentation that I will have to sort of divert to your documents. That's a document specific issue. That's a document specific issue. So don't shoot the messenger there. But that's why actually looking at your documents and understanding what's inside of your documents is actually very important. You can't always rely on the statute. The statute sometimes sets you up with a default provision, but it says unless provided in your documents. So don't think that that's like the rule. It's sort of the default in a lot of situations. So decisions of the association membership now we're talking about. Unless otherwise provided in the Condominium Act or in your documents, decisions can be made by a majority of the quorum. And I always say that that's sort of like a sliding scale. It's not a majority of the majority, it's a majority of those who participate. So if you get 70% participation on, let's say, waiving reserves, because that's a majority of a quorum vote, then you need a majority of the 70%. So that's something that's commonly misinterpreted, and I try to describe it as a sliding scale, which I think is helpful to a lot of people. Membership right to attend meetings, speak on meetings, videotape meetings. Listen, this is the same for membership, board, and committee meetings, so I'm only going to say it one time. Unit owners have the right to attend all association meetings, with a caveat that we'll talk about probably shortly. They can speak on all agenda items, and they can audio and video record meetings. You are permitted to, as a board, adopt reasonable rules governing how unit owners are going to speak at meetings, whether there's a sign-up sheet, whether they're limited to 3-minute statements, how this is all going to work out. But remember, you can't adopt rules that basically eliminate the right of unit owners to speak. So these are reasonable rules regarding frequency, duration, and manner of participation. I get questions a lot regarding the audio and video recording, because here in Florida, we're known as a two-party consent state when it comes to audio recordings. When you're out and, in a place where you think it's somewhat private, and you're not allowed to audio, or on the telephone, you're not allowed to audio tape somebody without their consent. Videotaping, as long as it's done in the public realm, that is something different. But audio recording is sort of protected here in Florida. Here we have an exception to the general rule that by virtue of your attendance at a board meeting, as a unit owner membership meeting, committee meeting, you are putting yourself out there to essentially approve of your audio being recorded. You can only adopt several very specific rules here regarding audio videotaping, and probably the one that's the most important is requiring a unit owner to announce that they are recording before the meeting, like as the meeting starts. So, while I think people will do it anyway, that is a rule that you might want to think about getting on to your books in writing. So then if somebody records without announcing that they're doing it, you have some sort of claim that that was an improper recording. So that is a rule that I would probably recommend. The other ones, you can't be disruptive in your recording. That's sort of implied, right? You can't disrupt meetings with that kind of thing. So just realize that this exists. A lot of association boards that I work with who don't attend these type of courses are really taken aback once they find out that owners can audio and video record, and it's never happened before. Then somebody all of a sudden comes to a meeting and says they're doing it. And, I've had boards that just walk out because they believe that it's improper, but that is not the case. And by serving on your board and attending a meeting as a unit owner, you are subject to this. So you need to act professional. You do not want to act improper or unprofessional, have somebody record it and then have it show up on some sort of association website or in the public. That is a lot of times embarrassing, and obviously that's happened to associations before. So please be aware of all of that. Voting at membership meetings. You can vote by, most times you're going to be voting by limited proxy. That's called I consider that a directed proxy, that you check off a box concerning how you want to vote, and somebody else basically delivers that vote to the association and casts the ballot for you. General proxies just allow you to establish really a quorum, but you cannot vote by general proxy in a condominium association. For those of you who might also own homes and homeowners associations, manage homeowners associations, previously lived in a homeowners association, general proxies can be used for substantive votes for election of directors, and it's a completely different animal. Condominium law is completely separate, and we do not allow those general proxies for substantive votes. A proxy is valid for 90 days from the date of the meeting that it is given for. So if, for example, you're trying to vote on this amendment that you find very important, it's a leasing amendment. You're trying to say that you can only lease for no less than 3 months. We'll use that as an example. And you have a meeting scheduled for February 1st, and you realize, shortly before the meeting that you don't think you're going to get this vote. You've been working on it for 3 years. This is very important to you. You can not take the vote at the meeting and adjourn and continue the meeting basically for up to 90 days and add votes to the votes that you have. So those originally submitted proxies stay valid. Maybe you'll reschedule it for 30 days. You'll say, you know what, we're going to continue this meeting till March 1st, March 2nd, 3rd, and then you'll have those original proxies and any new proxies that are submitted, which will count. However, keep in mind, number 5 right here, every proxy is revocable until the time, you call the vote. So if one of those owners who gave a proxy for the February 1 meeting changed their mind and said, you know what, I don't want to approve this amendment. Mr. Jones got to me and told me that this isn't going to be helpful. It's going to lower our value of our units and make them less marketable. I don't want to agree to this. Then you can submit a new proxy, a later dated proxy that will supersede the originally provided proxy. I'm going to just quickly check the QA here to see if we have any pertinent questions here.
That first question is talking about when you were mentioning the recording of board meetings.
Well, here I was talking about that unit owners have the right to record meetings. The question here is if a community member requests to video record a board of directors meeting, and if it's used for litigation, must it be transcribed for all to read? I don't really understand that question, but the fact is that unit owners have the right to record. You can't get it from the unit owner once they do it for their personal. If they're doing it personally, no. Maybe if you're in litigation and get it through discovery. If the association records the meeting, it possibly opens that up to becoming an official record. There's sort of a split of opinion there of whether video recordings are part of an association's official records or not. There's arguments on both sides to that, I think. Let's see. I think some of these. Oh, we have a good question here, and I usually do talk about this. My friend Barry, if unit owners consent to receive notice by email, can't all other owners get their email addresses? Okay, let me explain this. If you have provided your email address to your association because you said, you know what, I want to opt in to get notice via email. I want to be helpful and reduce mailing costs. Please be aware, to all of you who do that, the email address that you give to the association for purposes of the notice then becomes part of the official records of the association, accessible by all other unit owners. So if you don't want to give your email address to the whole membership because you don't want to get the, complaints or I'm sure you all know all the mass emails, or they'll use it to, do promotional activities, then I always recommend that you create some sort of alternative email address for just that purpose, that you have, Allison Hertz Condo ABC at gmail.com, just for purposes of your notice with that association, so that if other owners get access to that, you're not flooded with all kinds of emails. So thanks for that pertinent question, and I'll continue to check the Q&A, but let's move on for now. Okay, election of directors. This is a very detailed topic. I do have like a whole course on this, but so I'm gonna have to be like over general, and I never like being over general, but we're gonna have to do that for the good of moving this presentation along. The number of board members
How many board members are supposed to be serving? That is a very frequent question we receive at the law firm because it's kind of confusing sometimes. I mean, your bylaws and articles are supposed to let you know how many members are supposed to be serving. Sometimes it will be very straightforward. It'll say 3 members, 5 members, but then it'll sometimes get a little more hairy when it says between 3 and 9 members to be determined by the membership at the election. Well, we can't do that because we all know that you have an absentee ballot sent out no less than 14 days in advance, which must contain the number of people to be elected. So in that case, actually, it will default to 5. This is an area that if you have any question or concern regarding the number of directors, I would highly encourage you to talk to your lawyer about this because it's not as straightforward as it may seem to be. If you're in a association governing less than 10 unit owners, 10 units, you can have some kind of alternative processes for your election if you have them in your bylaws. But all this stuff mostly applies to everybody out there, by the way. This is all procedural, and to my knowledge, all of the statutory procedural election laws are going to apply to most of you out there, particularly in a residential setting. There are some exceptions for non-residential. If you're in a non-residential office condo, medical condo, something that's clearly non-residential, actually you can use general proxies for voting for board members, and there's certain other exceptions, but going forward, I'm probably going to mostly focus on residential because I believe most of you out there are residential or mixed use, and probably this is not, you know, a course that's geared more to commercial. But just know, if you're in a commercial or non-residential, then some of these things you might have exceptions for. And once again, you'll have to talk to your lawyer out there to see what exactly applies to you there. A vacancy on the board. What if, you know, somebody moves, somebody passes away, somebody resigns because they can't take it anymore on the board? How do you deal with that? Well, unless otherwise provided in your documents, right, one of those document-specific issues, then the majority of the remaining directors can appoint a replacement. Let's see here. If you are in a let's see where we are. This is more on terms, I'm sorry. The terms of directors, how many years can you, what is the term? 1 year, 2 year, 2 year staggered terms? That's another document-specific issue at this point in time. We had the law flip-flop a bunch of times, whether you could have 2 year terms or only 1 year terms, but now the law has been clarified for a number of years that if you want to have 2 year straight terms, everybody serves 2 years, your bylaws can provide for that. If you want to have 3 year terms, your bylaws can provide for that. Typically speaking, it's going to be a 1 year term. That's the default. But my personal favorite is the 2 year staggered term, such that in a 5-member board, 2 or 3 directors are elected each year. As of July 1, 2018, we have a new law that came into effect saying that you cannot serve 8 consecutive years unless approved by an affirmative vote of owners representing 2/3 of all of the votes, or there are not enough eligible candidates to fill the vacancies. That law was prospective, so it really hasn't come into play yet, but it will come into play, and we will be dealing with that 8 years from July 1, 2018. If you have a situation where, let's just say you have 5 board members and you put out your notice of intent and only 3 people nominated themselves, well, those 3 people are going to be on the board and no election is required, and they can therefore appoint the other 2 members. If you have an election, or if you put out a notice for your 5 board members and 5 people respond, then you're done. That's pretty easy. That would be very nice because it's not a lot of work. I have that in several associations this year where I guess board members are doing a good job. They're keeping assessments reasonable and improving the property in a responsible manner. And you know what? Nobody else ran, and the board members submitted their notice, and that was that. As I mentioned, you have to be submitting your notice of intent to be a candidate 40 days prior to the date of the election, and you have to be you have to meet the eligibility criteria of the statute by that 40th day. Just to let you know, the statute is the place that provides for eligibility. Your documents cannot create additional eligibility requirements for board members other than that you must be a unit owner. I think that's the next slide here. Here we have all of the statutory eligibility requirements, which we'll go through. But oftentimes I see some old bylaws that provide that, you know, you can't, essentially, you can't be a snowbird if you want to be on the board. You have to be in residence at least 9 months out of the year. Well, that is not enforceable and not consistent with law. There are no eligibility additional requirements that can be created in your documents other than you have to be a unit owner to serve on the board. That is the one document specific thing. Oftentimes, associations believe that they have that restriction, that you have to be a unit owner to be on the board. But when we go look at the documents, it doesn't say that. So that could be something that you might want to take a look at, and you might want to amend your documents to provide that only unit owners can be on the board, because that is lawful. Who else is eligible? Well, you cannot be a convicted felon who hasn't had their rights restored for 5 years as of that 40th day. You cannot be suspended or removed by the division. That doesn't really come up very often, but what does come up often is number 3. A person who is delinquent in the payment of an assessment is not eligible to be a candidate. This is different. If you've served on your board for a long time, or if you've been a property manager for a long time, this law previously stated anybody delinquent in the payment of a monetary obligation was not eligible to be a candidate. So that would include, you know, parking fee, if you lease a parking space or pay an extra fee, if you didn't pay your fee. It would include fines. That was the real one that I think the legislature wanted to deal with here when they changed it to an assessment, because we had boards right before the election sort of going out crazy on fines and fining people, and then making it such that their opposition was not eligible for the board because they had yet to pay the fine. So this is now an assessment only. If you are an association or a manager who helps prepare the notice package, the first notice, I see a lot of times that people have the old language on the notice package, which, you know, I don't know if that would in and of itself jeopardize the election or make the election invalid. I don't know the answer to that question, but it would surely discourage people from nominating themselves when you're placing these type of requirements on the notice that aren't actually correct. So you should get this correct. This is the current law. In number 4, in a residential condominium association, now not a non-residential, of more than 10 units, co-owners cannot serve on the board at the same time unless they own more than 1 unit or there are not enough eligible candidates to fill vacancies. Just note that this provision about the co-owners serving on the board isn't an eligibility requirement. It's actually a service requirement. So these people can be put on the ballot. It's just if they both get elected, they both can't serve. That brings up, like, how do you deal with that? But we can talk about that more in the elections course. Okay, so the brief procedure for your election, because I'm trying to be quick here, 60 days before the scheduled election, the association must mail, deliver, or email the notice of the election concerning the date and time of the election and the address where you have to submit your notice of intent. Interestingly, it does not require you to include the location of the election. Maybe your bylaws require that, but it does not in the statute require the location or in the admin code. One very important thing to mention, which I think people neglect to deal with, is electronic voting. If you've authorized one of these electronic or online voting systems where you can basically vote in a portal, you need to, with the first notice, disclose the process and deadline to consent to electronic voting and basically tell people how to opt in and opt out of electronic voting with the first notice. If you don't include that protocol for online voting in the first notice, it's actually one of the things in the Florida admin code that causes your election to be completely invalid and you're going to have to start over. So that is an easy way to sort of screw up, and don't do that. I just advised an association about this because they were trying to implement the online voting, but I just wasn't sure if they were going to have enough time to do it because their first notice had to go out so quickly. So I didn't know if they really had enough time to deal with online voting. It's a 14-day notice, mobilize, and include that protocol with the first notice of election. So particularly managers out there, just definitely remember that. And it's really hard to keep track of all of the associations who've authorized online voting, but you might want to make that part of like your checklist that you have for that file. I surely do, to make sure that you recommend and kind of like keep tabs on that issue. We already said with 40 days before the date of the election, you have to submit your notice of intent. You know, this is something that you don't want to slip under the door. You want to do it in a means where you can prove delivery, certified mail, some kind of fax, even though it's sort of dated, but you do get that confirmation sheet, maybe an email with one of those read receipts that I'm not techie, so I don't know about. But some kind of means where you can show that it actually was delivered that 40th day. Because we have seen, you know, some instances where the association claims it never got the notice of intent. You know, we never got it. They're not required to issue a receipt to you. They're only required to do that if you deliver the notice in person. So if you deliver your notice of intent to be a candidate to the manager in his or her office and you hand it to them, that manager is required to give you a paper receipt. We got the notice on the 40th day. Otherwise, they don't have to give you any type of receipt. Would it be a bad idea to do so? No. And I know a lot of management companies and good managers who make that part of their practice to sort of have a check and balances and make everything fair. 35 days before the date of the election, you can submit a candidate information sheet. It's sort of like a resume or a platform, which is going to be included with the second notice with the ballot. You can describe why you're going to be a good board member or what your qualifications are, you know, complain about the prior board, current board, and what they did wrong and how you're going to make it better. We see all kinds of stuff here. The association is not allowed to redact anything or alter it. So this is an opportunity to say what you want to your members. A lot of times you don't have access to your membership emails or mailing addresses, or you know that they actually get mail at. So this is your time to say that no less than 14 days before the date of the election, or excuse me, no less than 14 or more than 34 days before the date of the election. That's when you get your second notice. By that time, we know if there's going to be an election or not, whether there's more candidates than vacancies, and that is the second notice package that's going to include the notice, the candidate information sheets, the ballot, the double envelopes, voting certificate. It's a lot of stuff, right? And that's kind of a difficult notice to send by email because if you have an election, you're going to need those envelopes. And I mean, maybe somebody can tell me how you send an envelope over email, but sending the envelopes is required. So I just don't think that that's a notice that you can send via email. You can establish online voting if you do that through the special process and you adopt that resolution and you tell everybody how to opt into it with the first notice. But I really don't see how you can do a second notice via email with no envelopes. The last little squib here on the ballot, I'm not sure if this is on another slide or not, but I'll just mention it here. The candidates must be listed in alphabetical order by last name. This is very important. If they're not, I think this is one of the instances that would result in an invalid election. So this is something that you could screw up, unfortunately. So just make sure they're listed in alphabetical order. There's no quorum requirement at the election meeting, but 20% of the eligible voters must cast a ballot. The election is actually done before the quorum is even established at a meeting because it's the first item of business that must be done at the meeting. So rather than needing a majority of owners to show up or submit a proxy for a quorum, you really focus on the number of election ballots returned in order to have your election. Oftentimes we'll have the election portion of the meeting because we have a lot of election ballots, but we don't have anybody who submitted a proxy, so we can't approve last year's minutes or do any other business because we don't have the majority. So keep that in mind. If your association is in a situation where it owns units, it foreclosed units by lien foreclosure, or it somehow otherwise acquired units, some type of mechanism for some kind of settlement, those votes are not, you're not allowed to cast your own vote in a condominium association. If you own a unit, the president or the secretary does not have the authority to cast a vote for those units, and they're actually they're deducted from the number of units that you need for, let's say, the 20% or the majority or some other threshold for a vote requirement. Elections are decided by a plurality of those ballots cast. What that means is whoever gets the most votes wins. Directors are elected by written ballot with those double envelopes. They're not by proxy unless you're in a timeshare or non-residential condominium. What I see oftentimes if you're up, getting ready to have your meeting, is that there are no ballots or envelopes at the meeting, that most people submitted it in advance and you just kind of forgot that somebody might come that day who has yet to cast a ballot. So if you are about to have your election meeting, just be sure that you have extra ballots and extra envelopes at the meeting, because that is required. And I've had instances where people have had to run back to the office or run back to their house to get these, and it really is not helpful because it holds up the whole meeting. I'm going to skip to the last slide here, number 5. If you want to challenge your election, you have to do so within 60 days after the date the election results are announced. So usually it's that night, that day, usually, unless the meeting's continued for some odd reason. This sometimes happened during our COVID era. But if you want to challenge, you only have 60 days. And that's a hard line. It's good because it gives some certainty to who's on the board for that term. And also just keep in mind that even with the 60 days, you have to send a pre-demand. Before you commence any litigation or arbitration regarding your election, you must first send a demand letter giving a reasonable amount of time for the association to act. So that is part of the challenge as well. We're probably not going to talk about that, so I wanted to mention then. As some of you probably know, been doing this a long time, who counts the ballots? Who deals with the ballots? Well, the ballots are dealt with by the impartial election committee, who are members of the association, who are not current board members, candidates for the board, or any of their spouses. That's very important. Sometimes, I ask now. I said, who are you? What is your relation? But back a long time ago, somebody might have got past me because I didn't realize it was a spouse of a board member who was on the election committee. That happened one time. It never happened again. So don't let that happen to you. The ballots have to be what's known as checked in, that you compare who voted, who signed the ballot, to who owns the unit on your roster list at the election meeting. That sometimes takes a really long time, hours, particularly when there are corporate entities that own units. So this is done at the beginning of the meeting, but you are allowed to have that process handled at a committee meeting earlier in the day. So if you have a very large number of units, you might want to have the check-in process noticed for, let's say, 2 o'clock, and your meeting starts at 7 o'clock for particularly those people who are in communities where a lot of people work and need to have meetings later in the night. So at least at that point, at least the ballots have been checked in, and then at 7 o'clock, you can just start pretty much opening the ballots. You're not going to open any ballots until the real meeting starts. The impartial committee is going to be checking to see if the true authorized voter cast the ballot. Then they'll be opening the outer envelope and separating the outer from the inner. Once the outer is off, then they start opening the inner. If anybody improperly voted, you'll write on the exterior envelope disregarded, invalid, something to that effect, and you'll put them to the side. You do not ever open those disregarded ballots. They're just kept in a stack, and all of that stuff's required to be kept for 1 year. That is a exception from the general 7-year for general records, or the perpetuity for meeting minutes. This is the online voting. You can establish this online voting through a resolution of the board. In order to adopt this, it has to be done at a meeting where there's a 14-day notice. You have to adopt a specific resolution that tells people how they can opt in and opt out of this online voting. But that doesn't, just because they opt into online voting, if they haven't consented to receive notice via email, you still would have to send them a paper notice. So you would probably want to do both of these at the same time. We have a lot of questions, so let me go back to this just very quickly. Do you have to file our board meeting minutes with the county? No, those are our internal minutes. Nothing gets filed with the county. If you have amendments to your documents that a board, your owners voted on an amendment to preclude leasing, yes, that type of thing is filed with the county. Can an annual meeting date be anticipated to meet budget scheduling time? Can you do your annual meeting and your budget meeting sort of at the same time? Well, the annual meeting is most oftentimes set in your bylaws. It probably says you have to have it on a day in March. Your budget meeting for a condominium has to be done no less than 14 days prior to the end of your fiscal year. So in that instance, no. So it really depends on what your bylaws say about the time and timing of the annual meeting. If your annual meeting occurs in early December or November, yeah, probably you could have them back to back. But not, the budget meeting is a board meeting and the annual meeting is a membership meeting. So those don't usually occur at the same time. Should you have an odd number of directors to prevent tied votes? Yes, I had one situation where the association insisted on having, 8 members, and it was a poor situation. I would definitely recommend an odd number, although shockingly, the statute doesn't address that. It really only addresses how many board members you have if your documents don't tell you how many you have, or if you're in a situation where, it's not feasible to determine the number at the election. Let me kind of go down. Somebody says, you mentioned 10 or fewer units, but your slide states 5. I don't think that's correct. The 10 or fewer units, I think, was related to co-owners serving on the board and adopting an election procedure that's different from the statutory procedure. That is the 10-unit issue. What if you can't get 5 people to serve and you have over, that's the number that you have? Well, you can run with 3, because 3 people is a quorum, but all 3 people would have to show up at every meeting. Just because you can't get 5 doesn't mean that now you're somehow have your board reduced to 3. So you got to talk to your lawyer about that, maybe, Brian. But, just because you can't get it doesn't mean they don't exist. Somebody else had a similar question. If only 4 or 5 board people are elected, can the new board vote with only 4 people? Yes, you can run with 4, but just realize you would have to have 3 people as a quorum. And we're getting into actually the board meeting section right now. So let's talk about that. This is online voting. This is vacancies. We did talk about that briefly. Officers, they don't get paid. Sorry about that. Notice of a board meeting. Okay, your organizational meeting, I think this is usually occurs to elect officers right after the annual meeting. but I like to have it a couple days later because sometimes people who are elected are not there that night, and that shouldn't prevent them from participating in the organizational meeting where you elect officers. So I tend to like the organizational meeting to be held, most bylaws say no more than 10 days after the election. So you'd want to do it as soon as possible to get your ducks in a row for banking purposes and other purposes. So that's just my personal preference there. Does the president vote? Yes, the president votes. A lot of people think for some reason, I guess, because in other organizations, other associations, completely separate, they're not under condominium law. Maybe they operate under Robert's rules, and they say that the president really only casts a vote in the event of a tie. That does not apply to condominium associations. Yes, of course, the president is going to vote. So we're going to, once I take a drink, get into the board meeting stuff now. Probably going to be pretty quick here because a lot of this we've already discussed. But I do like to talk about fiduciary duty, that board members must act reasonably and in the best interest of the association. Board members cannot be serving just because they want to, do something in their own self-interest. I mean, you can't be personally profiting off of your service on the board or using your service on the board to get an improper benefit. That is not okay. Can you suggest an amendment to allow pets because you like dogs? Yeah, sure, it's subject to unit owner approval. So that's not the same thing, but you should not be getting inside information to make money off of it, something like that. That is going to get you into a situation where you're in a breach of fiduciary duty situation. Can you make mistakes? Yes, you can make mistakes, but you can't do it for your own personal benefit. Board members are not going to be held personally liable for, making a poor decision, signing that one-page contract that you can't get out of, that on hindsight you probably shouldn't have signed. If you had the authority to enter into that type of contract, you did it at a board meeting, procedurally everything was right. I mean, that's an unfortunate situation, but you're not going to be personally responsible for signing a bad contract in most instances. So similar to that, I'd like to get into this page a little bit. No free lunch, no kickbacks. An officer, director, manager cannot accept anything or value for which consideration has not been provided. So you say, what the heck does that mean? Well, if you are going to enter into a landscape contract, you gotta analyze it, in good faith. The landscaper can't say, oh yeah, we'll give you a bunch of indoor nice plants if you sign this contract, wink, wink. That's completely improper, and this does happen. Unfortunately, it does happen. Anybody who does that is going to be subject to criminal investigations, criminal penalties. You just cannot accept services or goods where you didn't pay for them. That doesn't prevent you from entering into a raffle at a trade show or going to a seminar and picking up a free pencil from my booth, or we do have rulers, they're pretty good, or a pen. So, it's not that drastic, but you need to be, you need to have your eyes open here, because sometimes it's somewhat more benign than you would realize. Board members have come to me, I'm the association attorney, and said, oh, well, I have this other condo in, North Florida, and I'm an owner there, and I want a lease. And can you just tell me what you think about their governing documents? No, that they should pay for that service. I can't be providing them with free legal advice because they're on the board that I represent the association. So that's a little bit more benign, and sometimes you wouldn't even think that that's an issue. But you as a board member need to be considerate and kind of, think that stuff through so you don't get the finger pointed at you. Oh gosh, this one comes up a lot. Board members may use email to communicate to each other, but cannot use email to cast a vote on condominium association matters. The fact is we all email all day, every day, and you as board members can talk about association business on email. You can't agree to everything on email and run into a board meeting and say yes, yes, no, no, and have a 2-minute board meeting. I think that really circumvents the intent of having a board meeting. I think unit owners are entitled to hear your rationale and board discussion during board meetings. But the fact is that practically speaking, you have to sort of set yourself up for that board meeting and have some pre-discussion, and that is going to be okay to do in an email. Realize that you could be in a situation where unit owners want access to inter-board member emails. They make an official records request to access all emails between board members. And there are different attorneys who feel differently here. There's no, appellate case that we have to give you guidance here. But I will say that if you have an email address, Allison@abccondo.com, and everybody has the same email address that was set up by the management company or by a board member, that leads towards having those emails as official records. If it's your own personal email account, I think that leads towards your emails not being part of the official records. There are also, I believe, some division cases that provide that if you copy your manager on an email, that lends towards having it being accessible. So this is one of those lawyer things. Be careful what you put in writing, because push come to shove, these emails might be accessible by owners as part of official records access. And if you're in litigation and there's discovery out there, court-ordered production of documents, then it's definitely going to be able to get access. So you just got to be careful what you put in writing, and I think everyone knows that at this point. Board meeting notices generally require a 48-hour posted notice. There are other instances where it requires a longer notice, but post the notice on the property where you generally post notices. Has to contain an agenda for a condominium association, so it must contain a specific itemized list of what you plan to do at the board meeting. Just putting new business, that's not good enough for a condominium association. I always think that it should start off with consideration of landscape contract, consideration of new management company, consideration of hiring Allison Hertz as your attorney. No, I'm laughing to myself here now. But the point is to be detailed on your agenda. The owners deserve to know what you're going to consider at the meeting. If you're too vague, that can lead to challenges as to what you authorized. So be pretty detailed. Where you need a more lengthy notice, a 14-day notice, anytime you're considering a special assessment or anytime you're considering a rule regarding the use of a unit. If you're considering a special assessment, this is, I'm not one to try to over lawyer stuff or tell you need to get your lawyer involved in every single tiny little thing that you do as an association. There's so much to be done. But if you are going to be adopting a special assessment, that's one where you probably want to run the notice of the meeting by your lawyer. It has to include the estimated cost and purpose of the assessment, and it might have to include other, disclosures or other things because of what you're doing. If you're, getting a special assessment to repay a loan or some big deal item, you got to run that by your lawyer, because if you don't and you adopt the special assessment and you say it's due March 30th and somebody doesn't pay and you don't tell your lawyer till October, and then your lawyer finally looks at the notice when you go ask them to collect and they say, well, this, wasn't 14 days. You didn't have the estimated cost. You didn't have a detailed description of the purpose. Your lawyer's not going to be able to collect that for you. And now you're going to have to redo it and probably waive any interest or late fee that you thought was accruing during that time. So this is one of the things that you want to get right the first time. The other item is the amendment to rules regarding the use of a unit. And people say, well, what is that? What's an example? And really, to be conservative, anytime you're dealing with any rule regarding what's going on inside of a unit is where I say you need the 14-day notice. You don't need to send the actual proposed rule with the notice. You just need to say, hey, we're considering rules regarding use of a unit. Come to the meeting, hear about it. And then that's enough. This is a petition. You have the ability to petition the board to address a matter of business. This does not happen very frequently, but just realize it is there. This is when you can have a closed meeting. Closed meeting when it's not open to unit owners. And I think I did briefly mention that a little while ago. Realize that meetings that are closed still need notice. So you still need to post the 48-hour notice and take very, very brief minutes of the meetings. This is where you have a meeting with the attorney to discuss proposed or pending litigation or seek legal advice. That's typically what occurs if you want to talk to me about a covenant enforcement matter and we need to deal with somebody who failed to install the soundproofing in their unit and you're gearing up to make a demand on them or file some kind of litigation. Somebody's doing improper leasing and you need to have a closed meeting so it's not open and this person gets a heads up as to all of my legal strategies. You have a closed meeting. If you are having a meeting to discuss personnel matter, that is one where you can have a closed meeting without the lawyer present. That is an employee situation to me. Personnel does not mean hiring a management company. A management company is a vendor. That's not personnel, in my opinion. So you got to be careful in not using the personnel matter, quote, excuse, because I see people trying to kind of smush a lot of things in the box and say it's a personnel matter when it's clearly not a personnel matter. Here we have that owners can audio and videotape board meetings similar to unit owner meetings. We already talked about that. A quorum of the board must be present in order to conduct the board meeting. The statute actually is very specific here regarding electronic communication for board meetings. You can have board members attend board meetings by speakerphone, Zoom, whatever means you have available. They'll count towards the quorum, but you have to be able to hear these people and they have to be able to hear you. You can't, have somebody on a cell phone. Oh yeah, Joe says yes. Joe says no. Oh yeah, I have Betty on this phone. She says yes. And nobody can hear what they're saying because are they really even on the phone? So that's pretty common sense, but just mentioning. Board voting. Committee meetings, we'll go over this very quickly. This is a common misperception, actually. In a condominium association, all committee meetings have to be noticed and conducted in the same manner as board meetings. So if you have a social committee of your condominium association, they actually have to post a notice. If your bylaws can exempt committees from having to do that. Your bylaws can say, oh, committees don't have to be noticed or open. But even if your bylaws exclude these things, there are two special committees that always must have notice and must be open and must be treated sort of like board meetings. And these are committee meetings where the committee is taking final action on behalf of the board or making a recommendation or analyzing the association budget. Those are always opened, noticed, people can attend, speak, and they cannot be exempt. But as the second bullet point says, I personally don't recommend that you delegate any final action to a committee. I think all committees need to be advisory and make recommendations to the board. And if you choose to give them final authority, you better give them parameters and maybe ask for them to meet with you first and develop a protocol about it. But that is not recommended. Not recommended at all. 7 ways to get off the board. Resignation has to be in writing, by the way. If you just say at a board meeting because you get frustrated, I resign, I can't take it anymore. Well, that's not really effective. It has to be in writing. Recall of the director. If a majority of the entire voting interests vote to recall a member of the board, they are off the board. This is interesting. Delinquent in the payment of any monetary obligation due to the association for greater than 90 days. And here the statute was not changed to provide for assessment rather than monetary obligation. So if you're a board member who has a fine pending more than 90 days, you're off the board permanently. And it cannot get back on the board unless the board wants to appoint you. That's definitely something that you should think about. We've had board members, very good people, accidentally, I think genuinely, not pay an assessment for greater than 90 days because they were out of the country or something happened with the auto pay, and they are deemed to have abandoned their board seat, and the board does not have to automatically appoint them back on once they're paid up. That's that. If they don't want to appoint them back on, they're done. If you have criminal charges pending involving theft or embezzlement of the association funds, for a knowing and willful violation of the act, the division may order removal of a director. You're temporarily off the board if you fail to satisfy the board certification requirement. Or interestingly, if the board finds that an officer or director has violated a conflict of interest disclosure, the officer or director shall be deemed removed from office. I do also give a conflict of interest course. And it's an interesting course, but there's so much to talk about. We can't talk about all of that today. Okay, now to something that all of you might be interested in hearing about. This is the Senate Bill 4D that was enacted in May after the Surfside tragedy. I believe this was May 26th. It became effective, and a lot of this stuff is not necessarily triggered yet, but you must be planning for this because it's very important, and there's not that much time left on a lot of these things. The first aspect of this law was the milestone inspection. The milestone inspection is a physical inspection of the building to determine whether it has substantial deterioration. And this inspection, and let me just tell you, I'm going to sort of give a summary of this, but I urge you to go back through this PowerPoint and actually read these slides, because this is a lot of information to talk about in, I think I have less than an hour left to do this. So go back and read these slides because I'm going to be summarizing all of this right now. So this is basically inspection by a licensed engineer or architect to determine whether the building has substantial deterioration, and it goes into whether there's structural distress that negatively affects a building's general structure. Interestingly, the statute says that substantial deterioration does not include cracks, distortion, sagging, deflections, misalignment, signs of leakage, or peeling, unless the engineer or architect that's performing this says that this is substantial deterioration. A condominium association and a cooperative association, by the way, has to have this done basically every 30 years, once the building reaches 30 years, and every 10 years thereafter, generally speaking, for condominiums 3 stories or more in height. And this is specific to 3 stories or more. If you're actually a 3-story or more condominium in height and you're located within 3 miles of a coastline, you have to have this done once the building reaches 25 years of age. The age is based on the certificate of occupancy. The association board is the responsible for coordinating this at the association's cost. For condominiums that are already 30 years or 25 years and 3 miles from the coast, they must have the initial milestone inspection performed by December 31, 2024. And interestingly, the statute also says that you're going to receive a notice from the local enforcement agency basically advising you about this, saying that we've identified your building as one that needs a milestone inspection, and you must have the inspection done within 180 days after receiving this notice. Presumably, the local enforcement agency is going to time this such that you meet the December 31, 2024 deadline. We've seen various associations in various jurisdictions obtaining this 180-day notice, but a lot of people who probably need to comply by the end of 2024 have not received this notice yet. This inspection consists of 2 phases. The phase 1 is a visual inspection of the habitable and non-habitable areas to identify the substantial deterioration. If the substantial deterioration has not been found, the engineer architect issues a report to the association and the local enforcement agency, and you're done. If they do identify substantial deterioration, now you have another type of inspection that may involve destructive or non-destructive testing, or just a more intensive inspection. When you've finally identified that, you must start to deal with it. And if you don't, then the local jurisdiction can basically provide for fining or other enforcement mechanisms, and you don't want to get into that situation. I will say, oh, this is here. The repairs that are identified must be dealt with in a timely manner, and they must be commenced with 365 days after receiving that report. That's just commenced, not completed. We have a sort of a lack of vendors available probably to deal with this. But this is something I would like to say you should not delay on. A lot of you have condominium buildings that are at the 25-year or 30-year mark and do need the inspection on or before December 31, 2024. There are only so many licensed engineers or architects in Florida, frankly, who can perform these things. So this is something that you definitely want to investigate sooner than later. I know very few condominium associations who have completed it. I do know maybe some associations who have contracted for the work, and the work will be performed under a contract at a later time so as to comply with that deadline. But please be aware, if you fail to complete this, then it is by statute a breach of fiduciary duty of the board of directors. So if you're a board member and you're dealing with a 3-story or more condominium and you need this done, you need to get on this quickly. I'm not saying you need to go out and do it tomorrow, but you need to vet providers. You want a reputable engineer or architect who actually knows what they're doing, who can do this diligently and actually does this for a living. You want somebody who's qualified. And Jeff, what you want to do our survey? I put out a survey to see what the status is among you all out there. So for those of you who know you're required to have this milestone inspection completed by December 31, 2024, has your association either completed it or is it under contract for it to be completed by the deadline? So we're just trying to kind of gauge how many people are dealing with this or it's on their radar. So if you would kindly vote on our poll, I would really appreciate that. And I can't stress enough how important it is to get this underway. I think a lot of you who know about this are hoping that maybe there's some bill that gets filed in the next couple days or weeks or months that might extend this deadline. And, we just can't predict whether that's the case. I don't know if it will be the case. Will the legislature extend this? I'm just not so sure. This obviously is a safety bill that happened after a grave tragedy, and I'm not so sure that they're going to want to roll back those restrictions. On the other hand, like I said, there's only so many providers who can do these reports, and is there a need for it to be pushed back in order to get the providers available so we have sort of a rolling requirement and not so many people need to do it all at one time? So Jeff, can everybody see the results of this?
Yeah, are you seeing them on the screen now?
I'm seeing it on the screen. I just don't know.
Everybody should be seeing it. I'll read them out just in case. 84 people replied.
Okay,
and,
great.
43% said yes. 31% said no. And we had about 22 people. So 26% are not sure.
Okay. Well, actually, I'm actually pleasantly surprised that, 43% of the 83 people had said that they've done this or they're under contract to get it done. That's very good. For those of you who said you're not sure, you need to get read these slides once we're done with the course and figure it out, because this is really important. You're also, once you do this, you have to actually have a summary of the report and post it on your property and publish the full report in your website and actually send out a summary of the report to every owner, regardless of the findings. So this disclosure is provided to all of your unit owners, and then once your owners get it, they actually have to make it available as part of their sale. If they're going to sell the unit, it's part of the seller disclosure. So that's important to know as a unit owner, that once your association gets this, you have to give it to your potential buyers. So that was a very, very quick rendition of the milestone report, because we could talk about this for probably 2 hours. So who pays for it? The association. I told you it's a breach of fiduciary duty if the officers and directors knowingly and willfully fail to do it. Here we have the knowing and willful standard. So to me, if you get that notice that says you got to do it in 180 days and you still don't do it, that definitely goes to knowing and willfully. Exemptions, this is, again, 3 stories or more, and doesn't apply to, I guess I would call those like townhouse style condos, where you have 3 stories, 1 family, 2 family, 3 families, and they're all separate buildings. Maybe there's an exemption for that. The exemption is kind of poorly written in my opinion, but I think it has to do with those sort of single family type buildings that where there's not that many people living there. The other aspect of this law is the Structural Integrity Reserve Study, which is a study to determine the costs involved in deferred maintenance and replacement of the condominium property based on a visual inspection of the common areas by an engineer or architect. The Structural Integrity Reserve Study also applies to buildings 3 stories or higher. So if you're a building that's 2 stories, you don't have to get the reserve study, but you do have to, as of a certain time, fund mandatory components, which hopefully we'll have a time to talk about. Again, there's just so much to talk about in this course. At a minimum, the study has to be of the roof, load-bearing walls or other primary structural members, floor, foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, which is getting a lot of attention, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to replace the item negatively affects the other items listed in 1 through 9. So these are the components that the engineer or architect must go out and look at to determine the continuing cost that you must put away for part of your reserve to keep you on track for maintenance or replacement when that is needed. If, for example, you have a pool is not mentioned here, but if your pool is on your roof, obviously I would think the engineer or architect would also include that. If you have a seawall that helps protect your building, it's not on the list, but I would think the engineer or architect would include that as well. So there's many other items that would probably be included in the Structural Integrity Reserve Study that are not expressly listed in here. One of the items, interestingly, that's not included is elevator. Is elevator structural? I don't know. I'm not an engineer or architect, but it is a big ticket item. I'll say that for a reserve study. The visual inspection portion of this reserve is done by an engineer or architect. So once again, we're stretching our engineer and architects thin over the milestone report and the Structural Integrity Reserve Study. But the actual numbers, the report, can be prepared by a non-licensed engineer or architect, anybody qualified to prepare the report, which I don't recommend is you as a board member. That is just too much liability for you, or you as a manager. I just would feel very uncomfortable taking the work product of an engineer or architect and trying to put my own spin on the numbers there. So I think you have to hire a qualified professional to prepare the report. It's most likely going to be somebody who is an engineer or architect who's also qualified to run the numbers aspect here. So there's not that, I mean, there are a lot of people out there who are qualified reserve study professionals, but might not have the designation of an engineer or architect licensed in Florida. I would suspect this industry is going to have to mobilize and sort of team up, and we'll see a lot of different vendors sort of coming together to meet the needs of associations here, particularly if this law is not extended, because as mentioned, I actually had good timing here, that this must be completed also by December 31st, 2024. So Jeff, if you don't mind, I think we have a couple other slides here, but if you want to put up the other survey, that'd be great. Jeff, in the restroom break?
No, I'm coming. The firm had just called me about confirming something. So sorry for the delay there, folks. Let me get the second one up there.
So I just was curious, similar to the milestone, if
Here we go.
if you out there 3 stories or more, once again, if you've done this structural integrity reserve study, or if you have it under contract for it to be completed by the deadline, just to like kind of get an idea of what's out there and how many condos are in need of this and the timing factor. That would be great. Thank you, guys.
Numbers are looking relatively similar too, with the yes, no's, and not sures. I'll share it as soon as they slow down. And
Okay. And just to be broad speaking here, reserves are based on the estimated remaining useful life of the component. So those are going to change. If you've just had a roof repair done that enhances the life of the roof, that is going to change the estimated remaining useful life of the item. If you've just had a major restoration project where you've done, all the concrete restoration, that is going to change, improve the estimated remaining useful life of the structure of the building. So let's see. It's pretty much the same, I'd say, I think.
Yeah,
Just
very
a little
close.
bit less here.
Very close. 3 fewer people responded, but we have 39% with a yes, 40% with a no, and 21% are not yet sure about that.
Okay, well, again, that's good to hear that a lot of you are doing this and taking it seriously. And for those, and I think probably a lot of people are getting them done at the same time. I have several clients that have used the same vendor to do the milestone and the structural integrity reserve study simultaneously. So if you can take advantage of that, go ahead and do it. But, investigate this, get it in process, get bids, get the contract going, because if this deadline doesn't move, I am concerned that you will not have time to deal with it if you put it off for too long. And like the milestone inspection, that this is about developer controlled associations, you can look at that on your own. Just like the milestone inspection, if you fail to do it, then you're in breach of fiduciary duty as a board member. So if you don't do it, it's actually pretty serious. The law was amended in SB 4D. I kind of always forget about this because it's not, a breach of fiduciary duty item, but on or before January, so this is something that you should have already done, you were supposed to report to the Division of Florida Condominiums the number of buildings on the property that are 3 stories or more, the total number of units, the addresses of the buildings, and the counties in which all of these buildings are located, presumably so they can compile their own data to evaluate these laws and make recommendations and possibly do enforcement if their jurisdiction is expanded. The division does have jurisdiction to investigate whether an association has done the structural integrity reserve study, whether they've actually got the document, but they don't, I'm not so sure how much they really are going to be doing otherwise, but they do have the jurisdiction to look into that. In addition to having to provide the milestone report to buyers, you, as a seller of a condominium unit, you also have to provide a copy of the structural integrity reserve study. And if, as a seller, these items have not been completed and you don't have it, then you have to disclose that you don't have it yet. So you have to disclose one or the other as of, last year. So if you're going to sell or you're a realtor, a lot of you managers are also realtors and board members. In my experience, a lot of them are realtors too. Be aware that even the FAR bar condominium rider form is being changed to conform to these requirements. But I just don't know how much it's out there, with the general public, that they're aware of this stuff. So we have about a half an hour left in this course. We have quite a lot of material to cover in the half an hour. So I'm gonna try to run through some of the stuff as best as I can. As I told you, I just can't get through all of it. I can't help myself but to provide some detail on these items, or else I just don't think I'm doing my job by going over it, surface level. So I'm just gonna keep going. At 3:30, we will end the presentation because I don't like to keep people too long. I like to be early and not late. And I know everybody has business to do and things to do and places to be. So we'll just keep going through it. We already talked about budgets, and I mentioned that the board has to adopt the budget 14 days prior to the start of the association's fiscal year, or 14 days before the end of the current one, I think is what I stated previously. The budget meeting is a 14-day meeting notice. That's one of the special meeting notices. And don't forget that not only do you have to mail, hand deliver, or email the budget meeting notice, the notice has to include the proposed operating budget and reserve schedule with fully funded reserves. And that doesn't mean fully funded meaning you have to pay for every item within 1 year. It means that the contribution for the year has to be shown, that what the contribution would need to be to keep you on track to perform maintenance or deferred maintenance or replacement when the time comes. If the board wants to provide the owners with the ability to waive or reduce reserve contributions, it can do so until December 31, 2024. So you do still have the authority to waive or reduce reserves, and the division actually is interpreting this. Let me back up a little bit. The law change in SB 4D provides that as of December 31, 2024, you can no longer waive or reduce what are basically mandatory reserves. And those are the components that are listed in the Structural Integrity Reserve Study that I rattled off that list of the 10 items. And that's for buildings of all sizes. That's the Division of Florida Condominiums position. Their position also is that you can still waive or reduce for the 2025 fiscal year, but starting in 2026, there are mandatory reserves for all condominium associations that are non-waivable. You can't reduce them. And those are the items in the Structural Integrity Reserve Study. So as of basically 2026, there will be mandatory reserves and non-mandatory reserves. That's the state of the division's interpretation now. It's questionable, in my opinion, whether that truly should apply to buildings less than 3 stories, but that is the division's interpretation, and they're the agency that really investigates and fines for financial violations, and they enforce these financial regulations. So if I as a lawyer want to be conservative and obviously tell my clients to comply under their position. So you can still waive or reduce reserves for 2023, 2024, and 2025, but as of 2026, you're now having to contribute each year the full portion to keep you on track for that maintenance and repair. So if you're one of those associations that have historically waived for all of time and really have no reserves, you might want to think about, not waiving now totally and providing some reserve contribution, because if this law is not changed, extended, modified, if there's no glitch bill, as people like to say, your budget is going up substantially in 2026. So I want to, preface everything, moving forward with that. The board is the one that gives the owners the option of waiving or reducing. So if your board does not want to give the owner, if your board historically has said, you know what, we're going to waive, we're going to reduce, but with all the knowledge that you have now, you feel that that's probably not the most responsible thing to do, you as a board can provide for full funding for the year and not give the owners the option to do that. Maybe you want to not go full, but you want to be sort of at a reduced level. But if you're in that situation, you may think about providing more than nothing. That's what I'll say. And moving on. The annual financial statement has to be completed for the association each year, whether this is an audit, review, compilation, depends on the amount of assessment income that the amount of income that your association receives each year. You can reduce your financial reporting requirement with a vote of the owners. Be aware that, however, if your bylaws provide you shall have an annual audit each year, I'm not so sure that you can do anything but an annual audit. So that's something to look at. Here are the monetary thresholds that you want to look to. Review this presentation in more detail. Let's see, moving on. Transfer fees. A condominium association is not allowed to have a capital contribution, meaning that in order to get into the condominium association, you have to pay a year of assessments, 18 months of assessments. That is not lawful in a condominium association. It is in a homeowners association if it's in the homeowners association's governing documents. Here we're limited to a transfer fee in connection with the approval or review of a lease or sale. If you have the authority to actually screen and approve, the fee cannot exceed $150 per applicant. It actually used to be $100 per applicant, but it was finally increased after so many years to $150 in 2021. You also can charge a security deposit if your declaration, articles, or bylaws authorize you to charge a security deposit. It cannot exceed 1 month's rent, and it must be maintained in an escrow account similar to landlord-tenant security deposits. So it's something where you actually have to have this set up properly. If you have a management company, these security deposits become a lot more easy to handle because otherwise they can get kind of complicated. But it is beneficial to have the cash on hand because people like to say tenants don't treat the property as nice as owners, and if you have this security deposit and the tenant rams the gate, then you can tap into the security deposit. There's other ways to collect that too, but I'm just mentioning that as one. Estoppels, I usually go over this in quite a lot of detail, but I'm going to skip this topic for today because we have such little time left. And you can go read that. This is basically a document that the association is going to have to give a requester, usually in connection with the sale or financing of a unit. You can charge the statutory amounts for the estoppel. The estoppel contains a lot of information that's very important. If you have a form that you've been using for a really long time, then you need to really review that form and take a look at it to make sure that it actually says what you think it says. One of the items on the estoppel is regarding, right of first refusal. Does the association have the right of first refusal to buy units that once they're put on the market or once somebody enters into a contract? What if your documents did not have that, but then you amended your documents and now you do have that authority. So you just want to make sure your estoppel form is current with what your current documents say and what your current practices are. Board meeting minutes. This is something that I always like to talk about as well. Minutes are minutes. Minutes do not need to be verbatim records. That will get you into trouble. They should basically be, who was there at the meeting, what the call of the vote was, and discussion was had, and who voted in what manner. You don't say every little detail and Billy thought that the black door was too dark and wanted a gray one, and You know, somebody was complaining, you know, a unit owner stood up and made a complaint that the marble floor needed polishing because, you know, if there's a personal injury matter or if you have some sort of insurance claim and somebody else gets a hold of these board meeting minutes, they a lot of times can be taken out of context. And that's why I like to say they need to be brief. As I already mentioned, don't put anything you know, it could be damaging in writing, and that goes for minutes as well. They don't need to be very lengthy. Official records. Oh, let's get access to unit. Rules and regulations, we talked about that. They must be reasonable. They cannot contradict your other documents. 14-day notice for if they relate to use of a unit. Material alterations, that's another course, right? But that means when you're improving your common elements or association property and where you might need a vote of the owners to do so, the default of the statute says that you need a 75% voting interest vote to perform alterations before they're commenced unless otherwise provided in your document. So in your document, your declaration, specific actually, maybe your declaration says you need a majority vote of the owners to do alterations. Maybe your declaration says that you need a majority vote if the expense doesn't exceed 3% of your budget. Maybe you know, there's all kinds of material alteration provisions these days. So this is one particularly where it's going to be changing the look or expensive. You need to get your lawyer involved if you're interested in improving your property, either changing the look of something, changing the use of something. Moving back a couple years now, we had a lot of associations removing some type of amenity and a shuffleboard court and installing a pickleboard court. That's a material alteration. What does your declaration say about it? You better check before you do it, or else somebody will call you on it, and if they want to push it, they will win. Expense limitations, you know, it doesn't cost more than X% of your budget. Those are helpful because it allows the board to make, you know, improvements little by little, but be wary of those as well, because something that totally changes the look of your condominium might not be expensive. You know, the board might install some water fountain in the entryway that you just don't like it and you don't like the noise. Or I hear a lot of times that the pickleball courts are very noisy and you don't want that. It's close to your unit. So if you're interested in, you know, having an amendment to your declaration to change the procedure for alterations, think this through and think it through it. You know, you're going to be off the board soon and possibly not making these decisions, and think about, you know, what this could lead to in the future. If you have an alteration that is going to help with safety and welfare, basically you need something to assure that the property is not going to fall down or to assure the safety of the condominium, that will likely not need an approval. It will be exempt under Florida case law. Here, a famous case is that the association needed a seawall to prevent the property from essentially falling into the ocean. And the division said in that case, well, yeah, it's an alteration, but it's necessary to maintain the property, and therefore you can do it. That doesn't let you just like do whatever you want. It's a case-by-case basis, and you need backup from an engineer, architect type to show you, to, you know, have a report that this item is actually necessary, because this becomes very fact specific if you get challenged on it. Electrical vehicle charging stations and natural gas fuel stations are exempt from the material alteration rules. An owner can also display flags. An owner can put up a mezuzah on their door. There's also exceptions for telecommunication equipment under FCC law. So, you know, some of these things aren't as easy as you would think they are, that you would think that, oh no, an owner can't do it, it's a material alteration. But no, yes, they can, because the statute says that they can. Hurricane protection, we'll skip that. The leasing amendment, I'll leave it with this because my voice is like barely going at this point. And maybe I'll take a couple questions. But we talked about way back when in the presentation as an example a leasing amendment that we wanted to approve that said no leases less than 3 months. Leases have to be between 3 and 12 months. Well, leasing in condominiums is very well protected. The Florida Condominium Act was amended a long time ago to provide that there's grandfathering for leasing. If you have a declaration that says no leasing for less than 30 days, and there's an amendment proposing to change that for no less than 3 months, if you don't vote in favor of it, you're grandfathered, and you can still lease for no less than 30 days. You're not bound by the new amendment. So only those owners who consent to leasing amendments and who vote in favor of the new leasing amendments will be bound by the leasing amendments. And I think this is important to know before you go in and you tell your lawyer that we want a whole new transfer and leasing section of our document. Can you prepare an amendment? These amendments are not inexpensive for us to prepare. We can't just use a form and, give everybody the same thing. We put some thought into this. You have to look at various different things in your documents. So before you go down that road of trying to adopt a leasing amendment, I think it's important for you board members to know that even if the general membership approves the leasing amendment by 2/3 or whatever your document says regarding amendments, it's not going to apply to everyone. If those owners don't vote for it at all or vote no, then they are not subject to it. So not only do you have to know about this going in, but if you actually do this, you got to keep good records of who votes for it. If you have an owner voting by proxy or ballot, you got to have their name on it. You got to have some document that you can use should they then try to lease in violation of your new rule, that you could say, hey, Betty, you voted in favor of the leasing amendment right here. You signed it. Yes, you're bound by the amendment. So you have to keep very good records of this in order to assure that you can enforce it. So with that, I think I'm gonna, Jeff, I don't know what you think, but with about 10 minutes left, I think maybe we should go into some of the questions. Let's see.
Sounds good. I just put
Okay.
the link, since folks are not required to hang, excuse me, not required to hang on for the Q&A. We hope you do, but again, if you have to run, we get that. We just put the evaluation link into the chat. And let me briefly go over that, Allison, while you have some
Okay.
water to recuperate your voice a little bit. I know that was a lot, so thank you. And we had a few people in the Q&A saying, she needs water, give her some water. So, Joe, I'm talking about you. So let me just quickly share the screen. We just put the link into the chat. When you click on that link, it takes you here to this evaluation page, okay? At the top of the evaluation page, you'll see it says click here for the course materials. You click on that and you can get the slides that Allison used today. You can save them and download them here. If you need them emailed to you because you have some RAM or memory issues, just drop us an email at info@kbrlegal.com. But most of you should be able to download them from that link. So fill out your evaluation. It's not as long as it looks. It's not as bad as it looks. Hit submit, and then the confirmation screen forms a rectangular certificate. You can then go ahead and right click and save it, print it, take a screenshot with your keyboard, photograph it, save it that way. So that also answers a few questions that were in the chat about getting the certificate right away. That's how you do that. So I'll turn it back over to you now. And then folks, I'll go over this once again after Allison takes her few questions, and we'll go over it one more time. Back to you.
Okay. So does the grandfather clause for leasing amendments, does it continue with new owners? No. Once you sell, the new owner is going to be bound by the amendment. And actually, even if it's not a sale, if you transfer it to a trust, if your kids get it in a devise situation, so you need to be aware of that. That's a good question. I think 2 people had that question. Is a concrete seawall a material alteration? No. If your engineer or architect or some professional that knows about this gives you a report that it's necessary for the safety of the condominium property for the residents, it would not be an alteration. A lot of times we see this, where you have some kind of tile on catwalks or tile on your balcony, and your engineer or architect, this is a little bit different spin on it, suggests that you put down a new material because it helps prevent premature deterioration, and that you remove the tile. That's also not a material alteration. There's another division case regarding a Chattahoochee pool deck. I don't even know if anybody knows what that is these days. It's those little pebble rocks, where the association had those little pebble rocks in a pool deck, and they went to pavers. And they said, well, we wanted to go to pavers, not really for aesthetics, but because our consultant, whoever that person was, said that it was less slippery, more durable, going to last longer, going to prevent injuries. And that was not a material alteration either. So gets like very factual detail. People say, well, we don't want wallpaper. Well, I don't know what kind of excuse you can have to remove wallpaper, because it's not a safety issue, that's for sure. Is it going to prevent, moisture from getting into the walls? I don't know, but that's one that sort of comes up all the time. And if you don't have backup here, if you don't have a professional giving you a report saying it's necessary for better maintenance or necessary for safety, that's something where you want to get the vote of the membership in order to take the wallpaper off and just do paint. And that, I think a lot of people had that question, if you don't have that report, if it's not some necessary issue, does the board need an owner vote? Well, it's what your declaration says. If your declaration says you need a majority for material alterations, you need a majority. If your declaration does not address it, then it's 75% of the owners. Some declarations actually say it's the board that is the one that authorizes material alterations no matter what. That's what it is. If your declaration says the board can do it, the board can do it. Yes, Kim, you're going to get a copy of the slideshow. What about important updates like a new roof? Well, that's maintenance. Any kind of like normal course maintenance. If you have like a flat roof and you're replacing it with a new flat roof, and that's maintenance, that's not an alteration, and the board has the duty to assure the maintenance, repair, and replacement. So alteration issues only come up when there's a substantial change in appearance or use or function of the property. If you had a rec room where you had a ping pong table and a billiards table and card tables, and now you want to change that to a gym, arguably you're changing the use. Or if you want to change it to like an office area where there's little computer stations and maybe a printer that everyone can use, that's a material alteration. You're changing the use of the room. So this is very, very case by case. How long should minutes be kept, Carol? The statute was changed to provide that they have to be kept in perpetuity. It used to say 7 years, but as of a couple years back, you have to keep them forever. So you got to keep them forever.
That's a lot of minutes.
That's a lot of minutes. Are drone inspections kosher? That's a good question. I believe you're referring to the milestone inspection, I think, or maybe this structural integrity reserve study. I guess if the licensed engineer or architect is the one reviewing the drone footage, arguably yet to be determined, but that's a good question. Would a beach crossover be part of a Sears inspection? Well, that's obviously not listed in the statute, but if the beach crossover affects the structure of the building as determined by your engineer, then yes, it would be part of the Sears inspection. Oh, this is a good one, Lori, if you're still with us. What if the declaration states that unit owners are responsible for windows? Presumably, Lori is asking about the structural integrity reserve study, because the structural integrity reserve study lists windows as one of the mandatory components. My interpretation of that is that no, if it's the unit owner's responsibility, because the study is of the common areas. And typically, if unit owners are responsible, they're not going to be responsible for common area, common element. So I would suspect that's not part of it, but this is part of the law that, you know, needs clarification, and hopefully we'll get that in the next couple of years. If not, I think it's going to be difficult for the reserve advisor folks to deal with that. I suspect they'd sort of qualify it by either like not applicable or some kind of other qualification. I've not seen a report yet to see that yet. I see this is for all associations. There is no story requirement. Can you please clarify? The milestone inspection and the structural integrity reserve study, Susan, are for condos 3 stories or more. The only aspect that I spoke to regarding all condos was about reserve funding. So it's bizarre and interesting that the division says all condos, no matter what story, have to begin funding these mandatory components, but they don't have to have a study. But that's the position as of now. So as to the studies, 3 stories or more. As to the funding, all condominiums. What if we were a 2-story building on the intercoastal, but we've already started and had our 40-year inspection? You know, 2 stories, you're not related to 2 stories, Brian. We don't have 3 stories, Michael. That's good because you don't have to get the inspection. You might choose to do so anyway. Getting a reserve study done is always a good idea, so you know what your projections look like, but it's not required. Not required. Thought a structural engineer had to perform this. I'll leave this with, I understand in some jurisdictions, I believe Miami, that Miami is requiring certain engineers to perform the recertifications and allowing recertification to serve as a milestone inspection. And I believe that is in Miami-Dade. But they are 2 independent requirements. Michael, meaning when elected, they are already in default of the 90 days. I think you're talking about board members here. You cannot be delinquent at all in an assessment to be eligible for the board. Once you get on the board, if you then become 90 days delinquent in an assessment, you're deemed to have abandoned your office. So it's interesting. You can get on the board if you owe a fine, but once you get on the board and the fine is 90 days overdue, then you're deemed to have abandoned your office. The law doesn't really work well in that instance. I want to go to the conflict of interest party. Okay, well, if we get enough people who want to have that course, we will give that course. And with that, we're at the 3:30 mark. My voice is barely functioning, but I always enjoy giving these presentations, and I hope you enjoyed it as well and learned a lot. And please use the PowerPoint as a resource. You know, I was quite detailed about a lot of topics, but there are other topics in there regarding fining, official records requests, enforcement that you might want to get more information about. And I wish everybody well. Have a great week.